So this is a rather interesting case that has been filed in, I believe it's Ohio. And I'll go into it. This gentleman was a butcher, and he had a battery in his pants pocket, and it wound up with thermal runaway and caused him a lot of injuries. So he got a lawyer or a law firm to sue not only LG Chem, in regards to the batteries, but also I believe it's called Cleveland Vape Distribution. And but it never mentions in the complaint. I'm sure it's going to come up in the response to the complaint from the defendants exactly what else was in his pocket. I mean, the battery just being in your pocket, let's say there's nothing else in the pocket except the battery without it being inside of a case. I don't know, the chances of that exploding is rather rare. On the other hand, if you have keys or like, coins and things of that nature in your pocket and you don't have a battery in a case, probably it could very well explode. It never goes into exactly what was in his pocket. So I just want to preface this. But that'll come out if it ever goes to trial. This case probably settle out. Could very well be moved into summary judgment and even be dismissed. But if it does go to trial, what else was in his pocket? How much expertise did he have? This particular vapor, was he aware that he was supposed to have the battery in a case? Things of that nature. So anyway, I just want to give it a little preface to that. But here's the case itself. This is the complaint, and they're waiting on the response to the complaint. That's yet to come up. Why I do this is this is a rather interesting case because they actually sued the battery manufacturer. They not only sued the distributor, but they also sued the battery manufacturer, LG Chem, over there in Korea. And I'll show you a little of that information in a moment, other documents. Well, really a website. But what's interesting about this, though, is that, like I was explaining to Matt from Suck by Maud, I believe it was him. It was either him or someone else. Explaining that where the, like, for instance, I'll just take it from this way. Like in this particular case, it's where that intended use begins. So did it begin with LG Chem, or did it begin with the distribution company? Now, that's in regards to the Food and Drug Administration, okay, as far as intended use, okay? So don't mix that up with what's going on in this case. This has to do with product liability or tort claim. And like I said, I'm sure that the vapor, this particular gentleman, probably had something else in his pocket rather than just a battery in his pocket. And he ought to have known, even if he did put the battery in his pocket, he should have put it in a case. And we'll go to the Cleveland Vape Distribution website after I read a little bit of this complaint that was filed. So you have to understand, but anyway, the point is it's rather interesting that they actually, I mean, I can understand them going after the United States distribution company, but they actually are suing a foreign company And they had trouble actually serving LG Chem, and they actually had to have a special process server to do so. And that's yet to be completed. So when that's completed, then once that's served, then as far as Cleveland vape distribution, they've been served already. So they have, normally it's 20 days to respond to the complaint. As soon as the LG Chem is finally served, then they'll have 20 days to respond. But anyway, so let's get into this. So this is the, I cannot do that, Cuyahoga, maybe? I don't know. County Clerk of Courts. It's in Cleveland, Ohio. Court of Common Pleas. It was filed on June 25th, 2019. And this here, Thomas C. Merriman, is actually the law firm or lawyer. The judge is Emily Hagen. And the court case is CV 199172268, and it's Nader M. Harb versus LG Chem. And when you see this, meaning the following, which also includes the Cleveland vape distribution in the USA. I'm not going to go through all of this because of just get the gist of it. So they automatically, usually these civil cases are jury demand endorsed here on. Usually when they do a jury, it usually tends to settle before it gets to the jury. But anyways, this guy here out of Cleveland, Ohio, I don't want you to write him, okay? Don't write him and send him all kinds of stupid crap in the mail, okay? And this is LG Chem, South Korea, and then Cleveland Vape Distribution. And they served both particular addresses. Let me see that. So Harb is the plaintiff. So the nature of the action is, this is a product liability brought pursuant to Ohio RC, I guess that is the code. I don't know exactly what R stands for. But anyway, 2307.71 and the following, or whatever follows thereafter, arising from defendant's sale of unreasonably dangerous products that catastrophically fail during normal and foreseeable circumstances, with such failure causing Mr. Harb serious bodily injury. Now, this unreasonably dangerous products, I mean, I have over 25 batteries, and those batteries stay stacked in a certain area of the room. And whenever I put my batteries in the mod, I'm very careful about if there's any tears or any rips or any nicks, because I'll automatically rewrap. And I never put a battery ever in my pocket. And if it is in the pockets, in a case. And any time that I take a battery outside of the residence, I will always put it inside of a case. It says unreasonably dangerous products. What that means is that it is known to do this, that this product, these 18650s or 26650s or whatever they are, they're dangerous products. It's a blanket statement that's really unreasonable in and of itself, because they are not dangerous products if they are used properly. And I'll take you to the Cleveland vape distribution website, and it says it very clear in the description of one of the batteries that they are selling about what you ought to do and what you should do when you are handling batteries, these particular batteries. And then it said failed during normal and foreseeable circumstances. Now, that won't come out until later on when you get the responses back from the defendants. But I can almost guarantee that this battery in this particular butcher's pocket, pants pocket, was not in a case, and or it had keys in there, coins in there, who knows, pins in there, whatever kind of other metallic object in his pants when this particular battery went off and exploded. So to say it's normal, foreseeable circumstances, I'm going to beg to differ that that's just, once again, a blanket statement that's untrue. In other words, this lawyer or law firm is going to put their best foot forward and just to see what the defendants say. And all the defendants have to say, all the Cleveland vape distribution has to say is, we put it on our website what you need to do with the battery. And as far as LG Chem is concerned, all they really have to say is, well, our batteries are fine. And that particular battery that exploded was due to user fault. End the case. Now, what the law firm will have to do to prove that this particular battery was defective is actually test it to see if whatever's left of the battery was actually caused because of the battery or caused because of what the user or the vapor had in his pocket, meaning keys, coins, or whatever. I mean, if I take a battery, I take a Samsung 18650 25 hour, because that's normally what I use. I have other batteries, but that's normally what I use. Put that in my pocket with some coins and some keys. Probably my leg is going to get torn off like his leg was all torn off. It was burned and it was torn apart. It was almost like his skin was literally ripped from his bone. I saw a picture of it on the website. I could bring that up if you want to look at it. Anyway, anyone that could happen to. But that's due to not to LG Chem or to the Cleveland vape distribution. That's due to the vapor or to the user of that battery. So anyway, I just want to just clarify that. So anyway, so then the parties, jurisdiction, and venue, and you can see it all. I don't want to get it. I read it already, but I'm not going to, go into it too much. But it does say, in addition, defendant LG Chem has extensive ongoing and specific contacts with Ohio that include but are not limited to the following. At all times relevant herein, defendant LG Chem has had continuing contacts with Bambabang County by manufacturing, designing, testing, marketing, certifying, supplying, selling, importing, distributing goods, including but not limited to the subject LG HG2 battery, with the reasonable expectation that they will be used in this county and which are in fact used, sold, distributed, and retailed in this county. Now, you have to understand, the Food and Drug Administration does not have any standards out there in regards to batteries. I believe it was back in the early part of 2017 or the early part of 2018, they had battery workshops where they were supposed to get some standards on these batteries. In the FDA final rule, it states that in the future, they will have battery standards. But to this date, as of July 9th of 2019, the Food and Drug Administration, as well as the Center for Tobacco Products, has not put any battery standards out there. Not even, well, you ought to put warnings on these battery boxes or batteries themselves. It's strictly left up to either the importer, distributor, manufacturer, wholesaler, retailer, exporter, whatever else. It's pretty much all the categories there are. And this particular distributor on their website certainly has the warning there. Now, I believe this gentleman here actually went to the vape shop and bought the batteries. Did he see a warning in regards to the battery? I can't tell you. Doesn't mention that in this particular complaint. If he did see a warning in regards to the batteries, or did the employee or employer inform this particular customer of the warnings in regards to how you should handle a battery? And then it also goes to how long did this particular vapor vape? If he's been vaping for a few years, he should know better. If it's his very first device, then because it's an external battery mod, or it could be a 2-mech mod, fully mechanical box mod, it could be a regulated device, variable voltage, variable wattage, whatever. How much experience did he have? Did he ever put a battery in a case before? Why didn't he put the battery in a case now in regards to this particular case? So there's a lot of variables that will wind up coming out as these particular documents are submitted to the court. But right now, this is like all that's out there as far as the plaintiff, until the defendant actually responds to get a better idea of what's going on here. And then it'll be battled out in motions, and then they'll probably settle. But if not, there goes trial, and then you really see really what's going on here. And then it goes on a little bit more. So it says, in addition, defendant LG Chem's contacts with Ohio principally relate to the placement of electronic devices, including lithium-ion batteries, into the stream of commerce, and all the conduct associated with placing those products into the stream of commerce in Ohio, and associated with the civil actions related to and connected with the placement of batteries used in electronic cigarette devices into the stream of commerce. So like it says, therefore, at all times relevant herein, defendant LG Chem has purposely availed itself of the privilege of conducting business in the state of Ohio, has transacted business in the state of Ohio, has contracted to supply its products in the state of Ohio, has regularly caused its products to be sold in the state of Ohio, and this action arises out of business transacted in, as well as tortious actions and or omissions committed in whole or in part within Ohio, and which resulted in injuries to plaintiff in Ohio, and specific personal jurisdictions proper under one or more provisions of Ohio. I don't know. Let me pause this and find what this R means. 1 second. Okay, so the C stands for code, but the R stands for revise. So of Ohio Revised Code 2307.382, and usually what revised means it's been amended. This particular code has been amended, as well as the due process clauses of the 5th and 14th Amendments to the Constitution of the United States. So this is like all legal language here, and it's basically saying because LG Chem, even though it's a foreign company over there in Korea, because they participated in the interstate commerce, then they are liable to the plaintiff for any injury, caused him, So it's just, they're mainly saying that LG Chem, let's say if LG Chem was actually responsible, that when they get the damages, the money they were able to secure that money judgment against LG Chem, but they're far from that point. Take a little vape here myself. And get into little facts as to what an e-cigarette is all about. I don't think we necessarily need to go through all that. I think we understand what a battery is, probably better than the lawyer does. It gets into a little history with the monies and the time periods. And then talks about other cases that were related to battery explosions. Talks about thermal runaway. Now, this I take issue with. It says, in particular, lithium-ion batteries are susceptible to a condition known as thermal runaway. I mean, we all know that, right? Whereby the internal battery temperature can cause a fire or explosion, and which is often, that often word is, excuse my language, bullshit, which is often the result of poor design, use of low-quality materials, and manufacturing flaws and defects. Now, he has a footnote on that. So he's coming out of this here. And this is 2009. Let me pause this and I'm going to cross-reference and see how real this thing is. So all that is a volume of cases due to burns that particular patients have had due to batteries, but it doesn't necessarily say due to vaping in batteries. Understand it? It doesn't necessarily speak to the vaping experience with batteries. It's mainly about batteries in general. It could be car batteries. It could be laptops, cell phones, whatever. So see, you have to be, the lawyer is going to put the best foot forward. He's going to present his case, and then it's going to get holes poked into it. All right. Hopefully the lawyer realizes that there is more to the picture than what he presents to the court. This word here is what I take issue with often. I take serious issue with that. I've been vaping since April 2011, and I've never had a battery, literally by itself, explode on me. Never had one. I have batteries. I have over, I don't even know how many batteries I have. This is 12. I have like 30, 40 batteries over there. All types, 21700s, 2700s, 26650s, and mainly 18650s. They sit over there in that rack and never, ever explode. He's making it appear that they just so happen to explode. And I take serious issue with that. And hopefully the defendant's attorneys will bring that out. They don't often. And there are very rare cases that this happens. And when it does happen, usually it's due to user fault. And that eventually comes out in either trial or through the many motions that go back and forth between plaintiffs. I don't know, the Zoom cut out on me for a moment there. Anyway, I listened, so I have to piece this together in the editing. But anyway, as I was saying, this mainly goes back and forth through motions, through plaintiffs and defendants, and eventually the truth will come out. This word here often is BS. That's absolute bullshit that the lawyer is putting out. But like I said, the truth will come out eventually through all the motions, through the court documents. He's quoting, like I said, from cases that have nothing to do with vaping. But like I said, that will come out in time. Anyway, so then it continues on, talks about cigarettes as opposed to vaping. And it says, only a few federal regulations have been promulgated or proposed regarding e-cigarette sales and use. Many of these products are shipped from China and placed into stream of commerce without any knowledge as to what is in them, how they were made, or whether they are safe for consumers. Well, I will show you. See, you have to really, when you read a legal document, you have to read every single solitary word, because one word can turn the entire argument around, okay? So, like he says, without any knowledge? No, that's another bullshit con he's doing on the court. Of course, he's allowed to do this legally, okay? Don't get me wrong, because he's presenting his case, or presenting his case in reference to his plaintiff, who he's representing, in the best possible light that he can, okay? But hopefully the defendant's attorneys will catch these particular words and explain them more thoroughly to get an even balance to what's going on here to the court. So when he says without any knowledge as to what is in them is bull crap. How they were made is bull crap, because I'm going to show you on LG Chem's own website. It says how they're made, what is in them. Now, if he said without knowledge as to, then yeah, maybe to a degree, because maybe this user, this Nader guy, or Nader, wasn't aware of it or whatever. Maybe he should have done his research. Once again, it goes to his experience. How much vaping experience has he had? Has he just, this is first time mod he ever had, first external battery mod he ever had, whatever have you. Anyway, and it gets into a little bit of that, but not enough to know exactly where his head's at when it comes to these batteries. But to say any knowledge, no. Now, that's available to the public on LG Chem's website, and I'll show you that in a moment. So then they get into the FDA. See, and this is another, let me see what he says. Yeah. See, this is another thing, another con, which hopefully the defendants, plaintiffs, point out to the court that he was wrong. It says 2009, the United States Food and Drug Administration first attempted to regulate e-cigarettes. No, they didn't attempt. If you go into the congressional record, when they were actually debating the Tobacco Control Act, they spoke about e-cigarettes they did speak about it, but they didn't speak about it to the point that they were going to regulate it back in 2009. It didn't happen until May 10th of 2016 when they regulated e-cigarettes, and then August 8th, 2016 is when it was the effective date. But he's making it appear that they first attempted to regulate e-cigarettes back in 2009. No, not at all. It's not at all in the record like that. This is garbage he's putting out. So as e-cigarette manufacturers then successfully sued the FDA. No, see, he's got that mixed up. He's got the history of what's going on. Probably my hardcore subscribers know this better than this own attorney does. Understand? Where he gets this information, I have no clue. It says in 2009, they first attempted to regulate e-cigarettes. E-cigarette manufacturers then successfully sued the FDA. What? No, absolutely not. He's parsing the Enjoy case with the 2009 Tobacco Control Act. No, for one thing, the Tobacco Control Act of 2009 had nothing to do with e-cigarettes except for the deeming clause, but there was absolutely not one single solitary word in regards to vapor products, e-cigarettes, electronic nicotine delivery systems in the Family Smoking Prevention Tobacco Control Act of 2009. During that time, they said manufacturers. It's not manufacturers, it's manufacturer, meaning Enjoy or Cetera case. What they did was they sued the FDA because of they wanted to be considered tobacco products, and the FDA at that time could only regulate products that were drugs, cosmetics, and food. They didn't have power to do the tobacco or the slash vapor products, and that's where that Tobacco Control Act came about. But that had nothing to do. In other words, if we take it from this plaintiff's attorney's point of view, why didn't, if it was such, like he's saying, that first attempted to regulate e-cigarettes, why wasn't e-cigarettes or vapor products mentioned even slightly in the Tobacco Control Act of 2009? Wasn't even mentioned. Nothing at all with any language in there in regards to vaping as you and I know it. Even the most fundamental ego battery, it didn't even mention Han Lick's invention back in 2009 in this Tobacco Control Act. So he's really stretching the truth. I can only hope that that the plaintiff's attorneys read that, laugh, and correct this particular document that's being put forth. And then it says, claiming e-cigarettes should not be considered medical devices, subject to the provisions, boom. And that was Enjoy. Because of this ruling and lack of regulatory oversight, e-cigarette sales skyrocketed. Which may be true. I mean, maybe, possibly, if the Food and Drug Administration included vapor products back in 2009 in the Tobacco Control Act, yeah, maybe the sales wouldn't have skyrocketed. I don't know. Okay, we'd be like in the situation we're in now, but back in 2009. I can't tell you, but he's making it appear like sales skyrocketed. Well, who knows? I don't know. But the point is he's making it appear that the FDA put it in the Tobacco Control Act they made an attempt to first regulate vapor products in the Tobacco Control Act. No, it's not at all like that. And like I said, in the congressional record, so I did videos on this already. You have to search for them on this YouTube channel. In the congressional record, they threw the term out in regards to e-cigarettes. But if it was such a serious issue back in that time period, then they would have included that language in the Tobacco Control Act, which they did not. They just put the deeming clause in there. Anyway. So it says an October 2014 report notes the proposed FDA regulations do not include any consideration of the battery electronic components of the devices, as the FDA only addressing the health effects of vapor inhalation. Now, this is in regards to the notice of proposed rulemaking in regards to vapor products that went into the Federal Register on April 2014. And then I did videos of the U.S. Fire Administration in regards to vapor products exploding and things of that nature. And at least he got the August 8th, 2016 right, that the new FDA final rule took effect. Okay. And they have caused fires and explosions and injuring consumers. Numerous, yeah, there are several of them. I don't know if numerous. Numerous sounds like there's been thousands. There's several of them. And I would say 100 and under. Maybe even less than 50. But if you do it over the course of many years, instead of the recent year or two, yeah, I'd say about under 100 of them. Some of them aren't even reported. And this is, of course, the FAA or the United States Department of Transportation. And they mentioned, they're talking about vaping on a plane and how to do it with planes. And like it says, has determined e-cigarettes may not be used during flight. Don't necessarily have to go there with mic vapes, but there you go. and then talking about how individuals have been injured by batteries and things of that nature. And it says the defendant LG Chem, its agents, servants, and employees participated in the design, formulation, production, creation, making, construction, assembly, marketing, delivery, and sale of the LG HG2 batteries, including the subject LG HG2 battery. When they say subject, meaning that the specific one that actually blew his leg apart. So they're getting in right here. They're getting into the well, anyway, they're sort of getting into a little bit of the facts of the case. So here it is. So at or about 9 a.m. on the morning of June 8th, 2018, plaintiff reported to work at his place of employment in Cleveland, Ohio. At all times relevant, plaintiff worked as a butcher. Plaintiff regularly kept a spare battery on his person for use in his e-cigarette device in the event a replacement was needed to power his e-cigarette device. On the morning of June 8, 2018, plaintiff had the subject LG HG2 battery in the right front pocket of the long, heavy-duty pants he regularly wore when working. Now, this is key, and hopefully the defendant's attorneys for LG Chem and Cleveland Vape Distribution actually picks up on this. It's the right front pocket. Now, normally, unless the person is left-handed, normally your keys, I'm not saying all the time, but normally your keys will go in your right pocket. Think about it. And that's probably what was in his right pocket, was keys, coins, whatever else have you. Just a thought. Not saying it always happens that way, but that probably there were keys in his right pocket, because that's normally where they go when you put your keys in your pocket. And considering he's a man, he's going to put his keys in his pocket rather than a pocketbook. A woman tend to not put the keys in their pockets of their pants. They normally put the keys in their pocketbook. So hopefully they'll read this and understand what's going on here. On the morning of June 8th, 2018, plaintiff had the subject LG HG2 battery in his right front pocket so it might be utilized in the event that the battery inserted into his e-cigarette device ceased to supply power. At approximately 9:30 a.m. on the morning of June 8, 2018, the subject LG HG2 battery in plaintiff's right front pocket spontaneously exploded, setting his pants and leg on fire. Plaintiff then dropped and rolled to the floor and removed to his pants in an effort to extinguish the flames. Thereafter, on the morning of June 8, 2018, plaintiff was taken to Metro Health Medical Center in Cleveland, Ohio, where the emergency department referred him to Burn Clinic for treatment. He was joined by his wife. While at the Metro Health Medical Center Burn Clinic, it was determined that plaintiff had sustained an acute 2% TBSA burn of his right thigh as a result of the incident. See, so it happened from the right pocket, the right thigh. Okay, let me pause this and actually show you that burn, because it is a pretty nasty burn. Let me just pull that picture up. So as you can see on the screen, this here where the mouse is at, that is a pretty nasty burn. Don't get me wrong. I mean, that's pretty nasty looking. I mean, it did damage to him, serious damage. Okay, so I just want to, so you can have the visual in your head. So it says, has suffered and will continue to suffer the effects of permanent scarring due to the injuries sustained in the incident. And of course, well, this is where, money damages are at and all that stuff. Severe physical pain and mental anguish incurred substantial medical bills, lost wages, things of this is all the damage phase, So it says upon boom, and this is when they say upon information and belief doesn't necessarily mean that LG Chem was actually aware, even though it says defendant LG Chem was aware or should have been aware. Were defected due to their manufactured construction design, babom and babam, due to its inadequate warnings or instructions. Now, like I said, on the Cleveland vape distribution website, it gives the warnings. It goes into a little bit of where he actually got these batteries from. If he got them from the website, then he has absolutely no case. If he got it from the actual vape shop, because Cleveland vape distribution actually has vape shops. If he actually got it from the vape shop, then there could be a little bit in the favor of the plaintiff if they failed to tell him about the warnings on this particular battery. Because why put the warnings on the website, but you don't inform the purchaser in the vape shop of the same warning? So there might be a little gray area where the Cleveland Vape Distribution Company may have some liability, on that. But because they do have a legal duty, any retailer has a legal duty to not sell any kind of product. It doesn't just necessarily mean vapor products. Knowingly, you cannot, a retailer knowingly cannot sell a product that they know beforehand to cause harm to the customer. They can't do that because they have a legal duty to not do so. So then it gets into the causes of action, which we pretty much covered. As defendant LG Chem manufactured, assembled, distributed, tested, inspected, and sold the subject LG HG2 battery with actual constructive knowledge that it would be purchased and used by members of the general, this must be a little typo there, of the general public, such as plaintiff. The subject LG HG2 battery was expected to and did reach plaintiff without undergoing any substantial changes or alterations. That's a rather interesting line. I don't know why that plaintiff's attorney would put that in there, because it's saying that the battery was okay before it was sold. And yet he's saying that the battery was defective. That was hopefully the defendant's attorney will pick that up. See, it's not only expected to, but did reach plaintiff without undergoing any substantial changes or alterations. Rather interesting. Just a point to be made. So from the time the subject LG HG2 battery left the control of defendant LG Chem until the time of the incident, it did not undergo any substantial changes or alterations. What he's basically saying is that the plaintiff who got the injury did not change it in any way, but also can go also in the favor of LG Chem because this plaintiff's attorney is saying that the battery is defective. Rather interesting. Hopefully the defendant's attorneys pick this up. Pick that up. See, and yet it says the subject LG HG2 battery was defective in manufacture. Yet there were nothing, by the time it was So he's saying that was defective. Oh, I see what he's saying. So he's saying the time that they manufactured it was actually defective. Well, they have to prove that. It's not the burden of the defendants, attorneys or defendants, that is LG Chem and Cleveland Vape Distribution. It's not their burden to prove that to the court. The plaintiff has to prove to the court that this particular one battery that exploded was defective upon manufacturing. How he pulls that off, I have absolutely no clue. how he pulls that off, because the batteries exploded for one thing. It's a really a dicey case, but I presume that the plaintiff, this Harb Nader guy, gave him a serious amount of money to take the case on, because this is a bit, I mean, common sense tells. I mean, if I was an attorney, I certainly wouldn't take this case. I'll tell you that right now off the bat. There's too many variables in a case like this. You have to prove to the court that that battery was defective at the time of manufacturing it. How do you do that? That's crazy. I mean, the chances of you actually proving that is just. So it says the subject LGHG2 battery was defective in manufacture pursuant to Ohio Revised Code 2307.74, because upon information and belief, that doesn't cut it. But anyway, it deviated from design specifications, formulas, and or performance standards set forth by defendant LG Chem, because the subject LG HG2 battery was manufactured fabricated with materials that failed to resist the ordinary pressures, stress, thermal stress, fatigue stress, contrary to its anticipated intended design specifications, formulas, and or performance standards. And basically repeats itself over. Was manufactured and fabricated using materials that contributed to cause a condition whereby heat and energy could rapidly escape from the battery, contrary to its anticipated intended design specifications, formulas, and or performance standards. You know, this attorney had to have taken a retainer on this, because he's got to be an absolute fool to think that he's going to recoup any monies from this case. You know, that is money coming from, ordered by the court or by a jury. You know, and jury rules. I mean, in a civil trial, when it goes before a jury, they go by the preponderance of the evidence. So the preponderance of the evidence, all the defendant's attorneys have to show is that these batteries are like 99.9% of them. All they have to do is show statistically that these batteries are safe. But when they're used improperly, then these particular situations can happen. That's the preponderance of the evidence. That's all they have to show, defendants, that is. As far as the preponderance of the evidence coming from plaintiff's attorneys, they have to prove that this one particular battery was defective upon manufacturing this one particular battery that exploded, and then it was sold to the plaintiff. Not so much intentionally sold to the plaintiff to harm him or her. In this particular case, it's a him. But this somehow or another, this one particular battery came from Korea, went to the Cleveland Vape Distribution Company, and then was sold to the plaintiff, and so happened to blow up. That is so far-fetched. I mean, that is... That's crazy thinking. That's really crazy thinking. All I can say to this plaintiff is, whatever money you gave to your attorney, you lost that money. This is just so far-fetched. It's crazy. It's crazy thinking. So then he says, manufactured and or fabricated without a positive temperature coefficient thermistor or a similar device to prevent rapid discharge when short-circuited, leading to overheating, contrary to its see, now this positive here, you mean to see, this is really BS. I mean, you mean to tell me that this particular vapor, this Harb Nader guy, took the battery and that apparently did not have a positive on it? What? What? That even doesn't even make any sense. Doesn't even make any sense. I mean, the battery, why would he even put it in his pocket to use it in his device if the positive is not there? What's the point of it to even say, like, if it's even sold to him, he'd look at the battery and say, oh, doesn't have a positive. But let's say it was in a box. So maybe he didn't see it. Okay? He takes it home, takes it out, and as he puts it into his pocket, he's got to see that there's no positive there. Why use that particular battery that day on June 8th, 2018? Why use that particular battery on June 8th when it has no positive to it? What? What? Let me pause this and see exactly what that is. Thermistor. So as you see on the page, this is what he's talking about, this thing. I thought it was the actual positive on there. So they're saying that in the manufacturing process, this thing was defective in that one particular battery. Well, that could be something. I mean, he would have to have actual scientific analysis of that particular battery. Even though it exploded, he has to show that somehow or another, this particular thermistor, or whatever it's called, however you pronounce it, this THERMISTOR, the positive thermistor, was actually defective at time of manufacturing. Have fun trying to prove that in a court of law. Sharing that. Okay. So I thought it was the, the metal piece on top of the battery, because that would be like, wait, hold it here. It doesn't have that. Why even use it? So this is more inside of the battery itself. But how do you prove that at the time of manufacturing? I mean, that's crazy. I mean, they have quality control. So when they use, and that's all LG Chem has to show, that I'm sure this battery, whatever used, has a serial number attached to it. So they'll take that serial number. They'll look through all of their particular documentation over there at LG Chem and see if this particular battery was actually tested. And if it was tested properly, just like all the other batteries, then this plaintiff has absolutely no case. So it hinges, this entire case hinges on this particular thing here. It hinges on that. All right, whatever, we'll see what happens. Now, for instance, if LG Chem, when they tested that particular serial number or however they do it, their particular SKU on this particular one battery here, and they saw maybe some kind of fluctuation, or maybe it wasn't really up to par as to really sell this particular battery to the public, and that comes out in a court of law, then the plaintiff would win automatically, because that's product liability, that's product defect. Then, of course, it goes through as far as damages are concerned, as far as punitive damages, did LG Chem purposely say, yeah, well, I want to make a sale on all these batteries. I don't even care on this one battery. I want to make that sale even on the one battery that's defective that we know of. Send it out there anyway. Then there's punitive damages. That's when tens of millions of dollars are awarded to the plaintiff. But if the LG Chem saw that this battery was a little bit defective or something like that, and they just let it slip through. Is probably it's a little, maybe a little slightly $1 million or $2 million for punitive and the compensatory damages to pay for the medical bills and stuff like suffering and stuff like that. But they have to, LG Chem is going to be looking over their documentation because they test every single battery, or at least they're supposed to test every single battery that comes out of their plant. And this battery that exploded, it's amazing that they were able, apparently, according to the plaintiff's attorney, and he has to show that scientific analysis of this particular battery to the court, that this positive temperature coefficient thermistor actually failed or is defective when it was actually manufactured, and LG Chem was aware of it. That's a toughie. But he might be able to pull it off. Let's see what happens. Like it says, contrary to its little typo there. Contrary to its anticipated intended design specifications, formulas, and performance standards. Well, that comes in that quality control situation there. It says it was manufactured, the subject matter. When they say subject, like I said before, it doesn't mean all the batteries. Just means this one particular battery that exploded, okay, was manufactured and or fabricated without internal temperature controls, protection circuitry. Okay, well, hopefully he can prove all this. This is some serious stuff to actually say that LG Chem purposely put this one particular battery on the market knowing that it was defective. That's a bit of a stretch, but who knows? So once again, the same exploded battery was inadequate ventilation contrary, so it's inadequate ventilation. So in other words, this one particular exploded battery was defective, and LG Chem was aware of it. And they put it on the market anyway. I'm not talking about it's not about, you have to understand this. It's not about all the LG HG2 batteries out there. It only has to do with this one particular battery, which is probably one out of millions of batteries that are produced or manufactured by LG Chem every year. This one particular battery, LG Chem said, well, we want to make that $7 on this battery. Let's push it through anyway. I don't see LG Chem doing that, but who knows? It's crazy thinking. But anyway, whatever. And then talk about failure to prevent short circuiting leading to rapid discharge overheating. I'm telling you, he put it in his right pocket. There was keys in there or some coins in there, and exploded is what happened. And that's going to come out eventually in the court case. And then he's going through all this stuff here. It's usually what they will do is they'll put like a footnote on all this stuff that he's talking about, and it'll say see document or see exhibit, and reference a particular exhibit showing an actual scientific analysis of this one particular battery that was chemically tested by some lab to prove that, yes, it was because of this positive thermistor or whatever it's called, was defective at time of manufacturing. I don't see any of that in this particular complaint, but I'm sure if they have it, it'll eventually come out. Because what happens, you have a complaint, then you have the response from the defendants, and then you have a reply. Maybe in the reply, and I'm going to keep my my eye on this case because it's very interesting and very important. In the reply, maybe the plaintiff's attorney will actually show the exhibit, the scientific analysis of this one particular battery. So then this is where the harm or the damages. So debilitating personal injuries, permanent scarring. It says including but not limited to. So that means the court and or the jury can award even more than what they're asking for. Lost wages, medical expenses, loss of enjoyment of life. Okay, Kenny, and that's a bit, a bit of a stretch. I mean, can he still walk on the leg? He didn't necessarily lose his leg. Then yes, that could be serious loss of enjoyment of life. But he just got burned. Maybe his sex life might not be the greatest in the world. The girls might be like, "Ooh, look at that," No, I don't know. But say loss of enjoyment of life, I don't know. Maybe limited loss of enjoyment of life, but loss of enjoyment of life, I don't think so. Past and future emotional and physical pain and suffering. All right. So I know this video went on way too long, but I just wanted to. So they're mainly going after the defective design or formulation. So they're saying that this one particular battery, like it says, he's actually, let me see. So let me see what that says, because I read most of this complaint, but I didn't read it all. At all times relevant, defendant LG Chem is and was engaged in the business of designing, formulating, producing, creating, constructing, assembling, and marketing LG HG2 batteries, including the subject matter. Okay, well, that doesn't mean anything. See, they're mainly here. The foreseeable risks associated with the design of the subject LG HG2 battery exceeded the benefits associated with that design. So they're not going after all the batteries. They're going after just that one battery, which is the subject matter. So just after that one battery. I guess they, can prove that to the court of law that it somehow or another, this one battery, LG Chem said, well, we got to make that $7 on this battery. Let's put it through anyway. Because they have quality control over there at LG Chem, that if they see a defective battery, they test the battery. I'm going to presume for every possible situation, right? Heating, overheating, discharging, all that other stuff that goes along with batteries. Because it's going to show up in their documentation according to the serial number of this one particular subject matter, or this particular subject LG HG2 battery. It's going to show up in the LG Chem's documentation that this particular battery was quality control, or that is, it was tested for quality, was tested to its own standards, and then it passed. I'm telling you, it's mainly user fault. Majority of this stuff is user fault. I would say 99.4% of these particular explosions with batteries are due to user fault. Okay, so then it goes on there. Let me just pause this and see, get something else that's important, or I'm going to show you the other websites, and then we'll wrap this up. It says right here, the subject LG HG2 battery was designed without internal temperature controls and or protection circuitry. Well, these are unprotected circuitry batteries. I mean, it's common sense for one thing, but this goes to the warnings. Now, LG Chem, they show you the batteries and stuff like that. Cleveland Vape Distribution has a warning on their website. In their vape shops, I can't tell you what went down there. There might be some limited liability there. Anyway, let me pause this. So the third cause of action is inadequate warning or instruction. It says defendant LG Chem is strictly liable because when the subject LG HG2 battery left its control, it was defective. It was? Well, they have to prove that. the burden of proof is on the plaintiff's attorney to prove that. And unreasonably dangerous due to inadequate warnings or instructions for use because knew or in the exercise of reasonable care should have known that there was significant risk when you see it. And yet all those other batteries he mentioned, what I showed you before, where this plaintiff's attorney says that LG Chem produces all these other batteries. All these other batteries didn't have problems. I mean, maybe once in a while, but that's not the subject matter of this particular case. In other words, if this plaintiff's attorney could show that 50%, at least 50% of the LG Chem batteries explode left and right, then he doesn't really have a case. How does he prove that this one battery out of millions of batteries produced every year from LG Chem, I'm going to presume it's millions, it's maybe hundreds of thousands or tens of thousands, doesn't matter. I'm sure there are over 100,000 batteries that are produced, LG HG2 batteries. I'm sure it's over 100,000 a year. Worldwide, that is. It's distributed worldwide. How do they prove that this one battery out of all those other batteries was the cause of all this harm? It's just really far-fetched. I mean, he's really pushing it. He's really pushing it. In other words, if this plaintiff's attorney could show that there were at least 1,000 batteries of the HG2 batteries exploded in the last month or the last 6 months even, then yeah, maybe he could show that these batteries are defective by nature. But to say this, it's one battery, just one battery out of all the millions of batteries that LG Chem does manufacture, somehow or another, this one little battery here caused all this harm. Whew. That is, wow. Okay. That's really pushing it. That is really pushing it. If I was on that jury, just with the complaint itself, and let's say, unless they could provide scientific analysis that this one particular battery, in regards to the positive temperature coefficient thermistor, and it's broken down in the court before the jury and explained to the court, both sides explain it. You understand exactly what this thing here is that I'm showing you on the page. This thing here, this little thing. If I could understand this, what this is all about as a juror, and I can contribute the defect to LG Chem, and they knew that this particular one battery had this particular thermistor, or however you say it, actually was defective, and yet they let it through, and they let it, to be sold worldwide, and it so happened to wind up injuring this one particular person, then yes, if they could prove that through science, yes, then I would award that particular plaintiff monies. On the other hand, if they can't do that, in regards to preponderance of the evidence, I would persuade the other jurors on that jury to come up with a decision that is for LG Chem rather than against it. They have to prove that through the preponderance of the evidence that the liability falls to the LG Chem and not to the user. Probably if it ever goes to trial and goes before a jury, the jury is going to realize eventually that it's really due to the user's fault of this particular battery in his particular pocket at that particular time. It's probably going to be shown before the jury when the jury decides. At least that's how I would, because it's not even so much Well, it's a combination of, did LG Chem, can they provide documentation? Probably they will provide documentation that they tested this battery, this particular one battery, because I'm sure it has a serial number somehow or another on it. They tested the battery and it was fine when it left the manufacturing plant. And then the other flip side of that situation is what did the plaintiff do with that particular battery when that particular plaintiff or user or vapor used that battery? So if LG Chem can prove to the court or to the jury, if it goes into a trial, usually it's settled out, but let's say, or it doesn't even rise to the level of being able to go before a jury. The judge can actually dismiss the case right out after all the motions are presented, all the responses, replies, all that stuff is presented to the court. The judge can dismiss the entire case before it even goes before a jury. But if LG Chem can prove that they tested the battery, everything was cool, when it left, boom, 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 then it falls to the user. And if that's the case, then I would completely say, well, that the liability does not rest with LG Chem. Anyway, let me pause this. And it says LG Chem failed to provide warnings or instructions that a manufacturer exercising reasonable care would have provided concerning the risk of energizing explosion in light of the boom boom known uses and environments of use. Now, I'm going to try to find those warnings on the LG Chem website. So far, I've been unable to find them. But you know, the other thing with this is, this particular vapor did not buy the battery directly from LG Chem. So there was really no reason for LG Chem to have those warnings on their website. I mean, they should have the warnings on their website. Now, this is, of course, also, you have to understand, goes into Korean law. So you have to understand, does Korea itself expect LG Chem to have these warnings on their website? But of course, LG Chem is participating in the interstate commerce in the United States. So when they sell their products to a distributor in the United States, they are also liable or culpable to those particular U.S. laws. Now, the funny thing about it all is that as far as the Food and Drug Administration, they don't necessarily have any standards in place. In fact, they have no standards in place when it comes to batteries. And they're the ones that would be issuing these warnings that would be required in the U.S. markets and its territories. Now, like I said, Cleveland Vape Distribution, and many places where you buy batteries online in the USA, provide those warnings just because, mainly because they want to, you know, rid themselves of any liability. But they don't have to, because the Food and Drug Administration does not require them to do so, at least not yet. As far as good manufacturing practices and things of that nature, that has nothing to do with Cleveland Vape Distribution. Now, as far as just a retailer participating in the interstate commerce in the U.S. markets and its territories, they do have a legal duty not to sell harmful products to their customers. Did Cleveland Vape Distribution knowingly sell this defective one battery out of, who knows, probably 500 other batteries that are in their stock rooms? They deliberately sold this one defective, supposedly, allegedly, one defective battery to this customer? That is just freaking insane. That they sort out this one battery And they knew that this one battery out of all the hundreds of other batteries or whatever, however amount of batteries they have in their distribution centers, they have 2 of them, knowingly sold this one battery to this customer, knowing that it actually was defective. I mean, it's just, this plaintiff's attorney is just stretching the truth. They're just, he's really pushing it. He's really, really pushing it. But, you know, we'll see what happens. Now, there might be something in the Ohio statute that says that you have to have warnings or instructions on batteries. So far, he doesn't cite that at all. He doesn't cite that statute, at least not yet. I haven't, like I said, I haven't read the whole thing. But so far, he hasn't cited any statutes, even Ohio statutes, that say that it's required a retailer to provide those warnings. Normally, they put that right into the complaint. See, again, upon information and belief. Information and belief, that is information coming from the plaintiff, upon his own understanding and belief, as well as whatever the plaintiff's attorney, whatever that law firm or lawyer investigated before they actually file this complaint, that also is upon information and belief. That's what that means anyway. Now, reasonable care, that's where that legal duty comes from. LG Chem failed to provide warnings that a manufacturer exercising reasonable care. That's normally, that's a normal legal standard. It's in pretty much everything, in especially product liability. Reasonable care, yeah. But then again, I'm sure LG Chem tested this one particular battery to make sure it was not defective before it left its plant. So, you know, there's a lot of variables in this particular case, and a lot of the variables do not point positively in the direction of the plaintiff. So this could very well be dismissed, this case. We'll see what happens. I'll keep up on it. So again, with the LG Chem, but let me see what he says about the Cleveland. As far as LG Chem, he didn't buy it from LG Chem. He bought it from Cleveland Vape Distribution. So let's see if they bring that up a little bit. So they didn't even bring that up. They kept on saying LG Chem. LG Chem doesn't necessarily have to provide that warning to that particular customer, because the customer did not buy the battery off of LG Chem. Now, on the other hand, if the purchaser or this particular plaintiff bought that battery directly off of LG Chem's website, then it's a whole different ballgame. But as far as these warnings are concerned, but he didn't buy it directly off of LG Chem's website. Now, what they're saying also is LG Chem should have put the warning on the box, maybe should have put it on the battery itself. Once again, this falls to the Food and Drug Administration. They have yet to put those warnings out there. They've yet to put any standards out there. There's a lot of variables in this stuff here. And the supplier, okay, now they're going to get into the Cleveland, okay. Defend the Cleveland Vape distribution supplier. Okay, see if they, let me pause this and get into this here. This is what could possibly, the plaintiff could possibly get money damages from this. We'll see what happens. Now, it says that the defendant Cleveland Vape owed a duty of reasonable care to plaintiff, breached that duty of care, failing to provide, no, he does this lawyer does a lot of typos. He should catch it. Actually, the legal secretary is actually typing this up, and she or he actually did a lot of typos here. But anyway, failing to provide adequate warnings to users and consumers. On the website, they have the warnings. It doesn't necessarily say this plaintiff actually bought it in the vape shop. No, I don't remember reading that at all in this complaint yet. And they're saying negligence. See, this is a biggie. So if they could prove that the Cleveland vape distribution committed negligence, this is where those punitive damages kick into play. And we'll see what happens. Again, with the Cleveland. See, and this is also stretching. This particular battery did not conform to representations with respect to safety during foreseeable use and or storage of the product. See, that's BS as well. For one thing, there are no safety standards coming out of the Food and Drug Administration. And as far as being foreseeable use and or storage of the product, that's up to the plaintiff to store it properly. You should have a case. Now, I'll tell you, I just thought of this. If this Cleveland vape distribution, when they sold the battery to the customer, and it included a plastic case, then they will be completely off the hook. Absolutely. That right there, completely off the hook as far as any liability. If they could prove to the court that they sold a plastic case either for the battery or the battery was actually in the plastic case, that would let Cleveland vape distribution off the hook completely, because it's telling the customer this battery needs to be in the plastic case. Or why else would you sell a plastic case to a customer? So that would definitely let them off the hook. But it doesn't say anything in here that there was, okay, so here you go. This is good. Okay, sure. Okay. So as a director, plaintiff was unaware of the dangers associated with the use and storage of the battery, including the risk that product would energize, explode, or catch fire. Once again, if Cleveland Vape Distribution sold a battery case or even included it for free to the customer, they're off the hook. They are absolutely off the hook as far as liability. On the other hand, should have or ought to have, but in this case, because there's no standards in place with the Food and Drug Administration, so it's not so much of an ought to unless Ohio statutes speak to it, and they apparently don't have any battery standards requirements in place under statute, at least not what I've read so far. It falls to let me pause this. I forgot my train of thought. Sorry. It falls to the plaintiff to, let's say if Cleveland Vape Distribution sold that plastic case or gave it to him for free, he should have known to put the battery in that case, unless it came in the case. So let's them off the hook. As far as storage of that particular battery, the plaintiff should have known as a vapor that it should be stored properly. Now, does Cleveland Vape Distribution have the legal or the duty of care to, when they sell that particular product to the customer, do they have a duty of care to inform that customer that it must be stored properly or in a plastic case, especially when you put it in your pocket? That goes under a couple things. Either Food and Drug Administration standards, which there are none, and or it goes to the Ohio statute. And so far they haven't cited any of the Ohio statutes. Now, if Ohio statute states that you must sell the battery in a storage unit or in a storage case, and Cleveland Vape Distribution failed to do that, then they're in serious trouble legally. But I'm sure there's nothing in the Ohio statute that says you have to have a battery and a plastic case together at all times. So, there's a lot of mitigating circumstances in here. It's not black and white. Of course, this plaintiff's attorney is going to make it appear black and white, but it's not black and white. There's a lot of variables involved here. And it mainly goes to the experience of the vapor. Did this plaintiff vape for a long period of time? I'll go you even one better. Did this vapor in his past history as a vapor? Where did he put those other batteries at? Where are these other batteries at? Are they in storage cases, in a dry, dark area of a room, or are they he just takes these batteries and throws them in a drawer somewhere, in a box somewhere, and there's all these batteries all flinged around everywhere. Every time you open the drawer up, they're all flying everywhere. How does he store those batteries in his place of residence? So there's a lot of questions, and I'm sure that's going to all come up when the defendants respond to this particular complaint. I'm sure the plaintiff's attorney said to the plaintiff that we have a slam dunk case, give me 10 grand or whatever, and that's pretty much where it ends at. The law firm made their money. The plaintiff's going to come up short, probably in this case. So when being used or stored is not in an open. Okay, so the risk of LGHG2 batteries energizing, exploding, and or catching fire when being used and or stored is not an open and obvious risk, nor is it a risk that is a matter of common knowledge. Now, again, that goes to the experience of this vapor. But then it also goes to the Ohio statutes. Does it say anything in there that has anything at all that says that the Cleveland Vape Distribution or any retailer or distributor or wholesaler or even manufacturer, even importer, exporter, but in this particular case, distributor, had a legal duty to instill that knowledge to that customer in regards to lithium-ion batteries or ion batteries, 18650s or whatever used. So far, he hasn't cited any Ohio statute. So I'm going to take it for granted that the Ohio statute does not speak to that. Or else he would have cited that. And it would have been a slam dunk case for the plaintiff as far as the Cleveland Vape Distribution if they fail to supply the knowledge and or the case, the plastic case, to that particular customer. But so far, he hasn't cited any of that Ohio statute. Unless he's saving that for his reply, but I doubt that very much. Normally, they put the statutes right off the bat in these complaints. Had defendant Cleveland Vape not misrepresented the safety during reasonable, plaintiff would not have purchased the battery. Now, once again, see, this is really BS. He's talking about this one particular battery. How did Cleveland Vape actually know that this one particular battery? I mean, if I was an attorney, I would love to represent Cleveland Vape Distribution in this case, because I'd win the case for them easily. There's so many variables. I love variables. So I understand all this stuff very thoroughly, very well. I would win the case for them. Absolutely. How did Cleveland Vape know that this one particular battery out of the hundreds of batteries that they have for sale caused this particular harm, or they knew that this one particular battery is going to cause this harm? That is crazy. That's crazy. Again, not misrepresented, had not misrepresented the safety. Again, it goes to the Ohio statute. There's nothing in there federally, as far as federal statute. The Food and Drug Administration has yet to issue any warning requirements or standards in regards to batteries, in regards to vaping. So therefore, it falls to Ohio statute. Now, I'm going to do maybe a little research on this on Ohio statute, and if I need to, I'll do like a follow-up video in regards to this particular video here, in regards to Ohio statute. If it speaks at all to batteries and safety and plastic cases and the retailer or the distributor or whatever have you had a legal duty to actually inform that particular plaintiff of, well, this is what you need to do with the battery and stuff like that. I doubt it very much that it's there, or else this particular plaintiff's attorney would have cited it in his complaint. But I'll do that as a follow-up. If there's no follow-up video, that means the Ohio statute does not speak to it. Okay, so in here it says defendants about the safety of the during reasonable was a direct and proximate cause of the harm. But this is, let me just pull that up real quick. I think this just has to do with harm in general. It doesn't speak specifically to batteries. Let me just pull that particular statute up. 1 second. It's just talking about harm in general. That's all that particular section is about. So they're saying here, if defendant LG Chem is not found liable in this judicial process, then they expect that Cleveland Vape will be found liable for compensatory damages. And then see, they're also seeking punitive damages, which only a jury, well, a judge, if it goes before a judge can also rule in regards to punitive damages. But this is probably, if it gets to that point, when it goes before the jury will be the ones that will award this plaintiff a lot of money. And this is basically a repeat of what I just read. So they're asking for plaintiff praise for judgment against each defendant jointly and severally, amount in excess of $25,000 for a compensatory damage, and in an amount excess of $25,000 on his complaint for punitive damages, as well as, of course, attorney's fees, costs, expenses, pre and post judgment interest, and whatever the court deems appropriate. So maybe the attorney either did have a retainer, or an attorney can actually have an upfront fee and then also other expenses that come thereafter for additional, like if they need to actually go to LG Chem, actually travel over there and inspect their manufacturing facility, they would have to have the judge's order to do so. And that it depends on Korean law if they recognize that particular judge's order. If not, then they would have to go to the Korean court to get a judge to rule in their favor as far as the plaintiff's attorney. It can get pretty complex, and that's when those attorney fees can very well go skyrocketing. I mean, skyrocketing. So that's why that stuff's included, even if he had given money up front to the attorney. Plaintiff hereby demands a trial by jury. So it's actually a law firm this is one lawyer on the case. He probably specializes in product liability claims, but it's coming out of this law firm here in Cleveland, Ohio. This guy, Pro Hack Vice, meaning he's in the process of actually being able to, he's in the process of being certified to represent the plaintiff in that particular court. So that's the plaintiffs. So let me pause this and bring up these websites, and then I'll end this. And then if I have to do a follow-up video to this, I will. Let me pause this a second. So this is Cleveland Vape. And so it's an actual e-cig and vapor lounge. And let me pause this real quick. 1 second here. So this is one of the distribution centers. This one is located at 17114 Detroit Road in Lakewood, Ohio. And they have the other one at Akron, Ohio. Okay, so this is just one of their places of, so this is one of the websites that they're, where they sell their products at, okay? So let's get into batteries. Now, right now, they don't have the LG, not that I know of, the batteries here. But let's do the batteries here, view all. So right now, they're not selling the LG battery. Why? No idea. Maybe just to be on the careful side. But let's go to Samsung. Okay. So they, you know, and it says right here, it says unprotected battery. Now, it doesn't say in the complaint that he actually, let me pause this and see if I could find anywhere where the plaintiff actually shopped at the vape shop. 1 second here. Let me pause this. So, like I said in the before, all it says in the complaint is plaintiff purchased LG HG2 lithium-ion batteries designed, including the LG HG2 battery from defendant Cleveland Vape on or about February 27, 2018. So it doesn't say if it was online or was in the vape shop. It also says you have to, what it's saying is he also purchased other LG HG2 lithium-ion batteries. Let me show you that real quick. We can understand what I'm looking at here. So let me make that a little bigger for you. So right here, this whole thing here, okay, the plaintiff purchased LG HG2 lithium batteries. See, so he, including the subject LG2 battery. So there was other LG HG2 batteries that he also purchased at the same time that he purchased this battery, or maybe on different times. But so he, and those batteries had no problem except for this one battery, like I was explaining before. But it doesn't say from defendant Cleveland Vape, but it doesn't say if he bought it online or offline. So anyway, let's go back to Cleveland Vape. And at least on the website, it said it gives you everything, okay? How to maintain the batteries. Make this a little bigger for you. Do not overcharge. Doing so, boom, boom. Please do not short circuit or it will release massive current. Do not play with fire, boom, boom. Do not stack. Always check for the battery's condition, signs of wear and tear. And then it says there is always inherent risk when using any rechargeable batteries at any time under any circumstances. And then it even says that they put their liability clause here that are not held responsible for any damage, for any modification of the batteries, will not be held responsible for any injury, damage, or defect in regards to the lithium ion. It says, please make sure that you have great knowledge on all rechargeable batteries before you use them. Always, and this is the main one here, always keep, store, and transport the rechargeable cells in a safe, non-conductive container. See? Now, if this particular plaintiff bought the batteries online, Cleveland Vape is off the hook. Is off the hook, period. It's not Cleveland Vape's responsibility to make sure that this particular individual reads all this stuff that's on the page. And most of these places that sell batteries will have all this stuff. So this particular line will leave Cleveland Vape off the hook. Now, let's see if I can find something here. Let me pause this. As you see on the screen, they also have a vape shop. See, Cleveland Vape, where the mouse is at. If you can see that, Cleveland Vape. They got pool table and everything. So if he bought the battery from the vape shop, then it gets a little bit more interesting as far as what's going on here. I'm sure they sell the battery with either a case or they inform them of. I'm sure they informed the customer that you have to have it with a case, or even when they sold the battery, they sold the case to the customer, or they provided for free. That could definitely let them off the hook. I can't see really in any of these pictures batteries. Let's see here. Show really any batteries here. I don't mean this to be a promo for Cleveland Vape, but just want to try to see if they show batteries and stuff, and cases would help. No, so they're not really showing any batteries and stuff like that, stuff. Anyway, so before I get into that, so as far as Cleveland Vape, I don't know if he bought it at the vape shop. If he bought it at the vape shop, he hopefully the Cleveland Vape company or distribution company had informed him of the batteries, but it appears by the complaint that he bought other batteries before and had no problem. The plaintiff didn't have any problem with the other batteries except this one battery. So it's rather interesting. I wonder exactly what was in that pocket that he put the battery in. If he ought to have known that he shouldn't have put it in his pocket. Why did he put it in his pocket? I'm sure and not only that, now, this is another thing. See, these are all variables you have to understand. If the battery was in a case and it was in his pocket, then the plaintiff's off the hook and LG Chem is on the hook, and the only way for LG Chem not to be on the hook is to prove through their documentation, through serial numbers, that particular battery was tested. When it left the manufacturing plant, it was fine. So there's a lot of variables here. There's a lot of questions that will eventually come out as this case moves forward. So anyway, and then if you go over to LG Chem, they show you a breakdown of batteries. And one of the batteries, they call it the mobile battery. And they're actually showing you the rechargeable battery, what it actually looks like. And it shows you the casing and everything of how it operates and what. I mean, just looking at this should tell you, you got to take care of this battery really well. So it provides lithium ion and all that other stuff in here. It doesn't necessarily, let me pause this real quick. LG Chem does a lot of stuff. Look at all the stuff they're involved in. I mean, they're not just into batteries. I always thought LG Chem was just about batteries, but they're into all kinds of stuff. Look at all the stuff that they're involved in. And this is mainly where we were at. They don't necessarily put a warning on their website in regards to these batteries. But that goes to Korean law. Does Korean law, you know, I might have to do, let me write that down real quick. Let me pause this. So this, it also goes to Korean law. So do they have, as far as product liability, do they have to have warnings on their websites, in their shops, in the retail shops? Mainly in this particular case, the manufacturing facility or in the website must show warnings in regards to their products. That's Korean law. So I'm going to look into that. So when I do my follow-up video, I will do, if you don't see a follow-up video in regards to this particular video, that means that there's nothing in Korean law that says anything about these warnings or batteries or cases and all this other stuff, or putting warnings, especially warnings up on their websites or whatever have you. Ohio statute speaking specifically to battery safety, they have to be in cases, plastic, how it's sold to customers and things of that nature. So if you don't see a follow-up video, that means Ohio statute as well as Korean law does not speak to these particular issues I'm raising. But yeah, there's nothing here as regarding, warnings, but I mean, they're selling them to distributors. I mean, I don't know if, I don't think LG Chem actually sells batteries from their website. They deal on, I mean, they have, a huge market and a huge, several products that are in the millions that they sell. They sell them to distributors and maybe directly to retailers, but normally to distributors, distributor down to wholesalers, to retailers on down the line. So there's a lot of variables in this here. Just to wrap it up here, Food and Drug Administration does not have battery standards in place. So there's no federal rule/statute that says, or law, I should say, not necessarily statute, but there's no federal rule or there's no federal law that says, that speaks to battery standards and cases and what a retailer should do and things of that nature, let alone manufacturer. As far as Ohio statute, well, I'm going to look into that. So we'll see what's going on with that. If I don't find anything, you won't get a follow-up video, and that means Ohio statute doesn't speak to it. So then it's just up to the to a jury, if it gets to that point, what is the, as far as the mitigating circumstances, considering the plaintiff bought LG HG2 batteries from this particular Cleveland vape before and had no problem with those batteries, just had only had a problem with this one specific battery. Was it due because of what was in his pocket? Maybe the battery was overused. Who knows? And who knows how that particular positive temperature coefficient thermistor or whatever it was, like I showed you. Maybe it was broke over a period of usage of that particular battery. We don't know how long this battery was in the possession of the purchaser or the plaintiff. So there's a lot of different variables in here. It's not cut and dry. I'm sure the plaintiff's attorneys are going to tell the plaintiff, going to tell Harb Nader, yes, it's cut and dry, we're going to win this case. It's not as cut and dry as you think. And when you have these variables that are in place, and it's a lot of gray area, normally what happens is it doesn't go before the jury. It gets settled. The case will get settled out. And normally what happens is normally LG Chem or Cleveland Vape say, look, okay, here's $25,000 here for compensatory damages and 10% above that or whatever. So maybe the guy walks away with 50 grand or whatever. So whatever it may be. 30,000, 27,000, whatever the hell it may be. But it won't be for what they're seeking, I'm sure, with the punitive damages is millions. with the information that the plaintiff's attorney supplied so far, the information that is submitted to the court so far, if I was a juror on that jury, that plaintiff would lose. So, but we have to see what the defendants say, and if they bring up all these variables that I've spoken about, then we get a much fuller picture. We get a clearer picture as to what really is going on here. And I'm going to presume that probably it has a lot to do with the plaintiff's or the use or fault of this particular battery. One battery, not only out of all the batteries he's purchased from Cleveland Vape, but all the batteries that LG Chem has manufactured, is this one battery. For some strange reason, this positive temperature coefficient thermistor failed to operate, properly. And the question is why? We'll see what happens. I'm going to keep my eye on this case. It's rather interesting. Anyway, so I know this is very long-winded. Anyone gets through this, my hat's off to you. Not many will. Maybe watch 5 minutes of the video and then they'll look at who's involved in the case and they'll do their own little Googling and pull it up and leave it at that. But anyone that lasted through the case will understand exactly not only this particular case, but how all these cases operate according to the law. So you get more knowledge, more insight into the court processes as well as what's going on with all these other variables in this particular case. Anyway, so I'm going to let you guys go. You guys have a good one. Bye-bye.